Well, I have to say it was the triumph of good over evil. It was the return of the golden age. It was the vindication of all that's good and right. It was the 42-27 dismantling of the Ohio State University Buckeyes by the glorious Michigan Wolverines.
In this episode of the FCPA Compliance Report, I welcome back James Koukios. We take a look at the Morrison and Foerster November top 10 international corruption developments. The issues we look at include the OECD updates for combating foreign bribery, a dismissal of an FCPA and money laundering case, the SEC and whistleblowers, former coal executive pleads guilty under an Egyptian bribery scheme, and corruption in an international adoption. All on this episode of the FCPA Compliance Report from the Compliance Podcast Network. Hello, everyone. This is Tom Fox. Welcome back for another episode. I am once again joined by MoFo partner James Koukios. Today, we're going to take a look at the firm's always great top 10 international anti-corruption development for this time for November 2021. But James, before we get there, we had another momentous development in November that you and I have to take some time to crow over. So, what did you see in November? A couple of different events that struck you as important.
Well, I have to say it was the triumph of good over evil. It was the return of the golden age. It was the vindication of all that's good and right. It was the 42-27 dismantling of the Ohio State University Buckeyes by the glorious Michigan Wolverines.
So it was pretty sweet, and then you were able to see the Big Ten championship game. We stumbled a little bit against Georgia, but on the whole, it was a heck of a season for the Blue.
Indeed it was. Go Blue.
So, James, on the newsletter, you started off by some commentary about the OECD recommending updates for combating foreign bribery. And I know you've been involved in the OECD a couple of times. I've been involved as well. But what did you see from the OECD new or different in this recommendation?
Sure. So way back in 2009, the OECD Working Group on Bribery put forth an anti-bribery recommendation that a couple things made recommendations to countries on how to best combat foreign bribery. So for various enforcement activities, public awareness drives, things like that. And then also they had their good practice guidance for companies on how to implement things in their compliance programs that will help fight anti-bribery. Obviously, the anti-bribery, foreign bribery landscape has changed tremendously over the last 12 years since that was released in 2009. And the OECD took a look and said, are there things that we can do to refresh that guidance and potentially supplement it where things have developed over the years? So that's really what they did. It's a highly technical document in many ways, and in many ways it is really more for countries and enforcement authorities. There were some tweaks to the good practice guidance for companies as well, but a lot of it was more technically directed towards countries and their enforcement agencies. A couple of things that I thought from that perspective were helpful. Number one, the OECD did recommend that countries do more to combat the demand side of bribery. Obviously, the FCPA is a supply side, meaning it focuses only on the bribe payers and not on the bribe receivers. And that is also what the OECD Anti-Bribery Convention does as well. But many people in the industry, companies, lots of folks have said, there's been not enough focus on bribe demands on the demand side, and so there needs to be more in that regard. And the OECD that was one of the recommendations that countries try to focus more on the demand side of bribery. Number two, and this is one that I really was interested in because my experience as a government and in private practice have been so different, and that's data protection. when I was a cynical federal prosecutor and a company came in and said, we can't provide you that document because of data privacy and data blocking laws, I just assumed it was a terrible document and they were trying to hide it from me. Um, our reaction was BS. Like, you're just trying to hide that. And then I got on this side and I said, "Hokey smokes, it's real." You actually, like, this is a big deal, especially for some clients in jurisdictions where there's actual real penalties for violating these laws. And it made for very tough discussions with DOJ, and it made difficult decisions with the client's part about how to cooperate. And so, one thing I was very happy to see was the OECD working group on bribery recommended that countries ensure that data protection laws do not unduly impede international law enforcement cooperation or corporate compliance programs. That would also be, obviously, third-party due diligence and things like that, because some people have expressed concern that GDPR can make it difficult for companies to do the third-party due diligence they need to do. So I thought it was really great that the OECD came forward and said data protection is important, data privacy is important, but let's be sensible about this and not enforce it in such a way that it either impedes enforcement or it impedes good compliance behaviors by companies. And so those are the two kind of big takeaways that I think were particular. I'm sure there are other ones that were significant as well, but those are the two that I really focused on.
James, next up we had a case probably only you and I and the rest of the FCPA geeks out there could really sink our teeth into. But there was a decision out of the Southern District of Texas dismissing an FCPA and money laundering charge against a Swiss wealth manager. What did you see in this case?
So this is one of our longer entries of all time, Tom, I think. And it's probably because I did geek out a little too much about it, but it was a very difficult, if I'm going to be frank, it was a very difficult to understand decision. Long story short, if I can oversimplify, the allegations are that there was a Swiss wealth manager who helped a bunch of dirty Venezuelans, both officials and some folks who were dealing with them, set up a series of um, shell companies and bank accounts and things like that to launder bribes. And this is involving the state-owned oil company of Venezuela, PDVSA. Essentially, that this Swiss wealth manager was assisting them in paying bribes and laundering the proceeds of the bribes. Um, Interesting fact pattern. She was based in Switzerland, never stepped foot in the United States as part of this, but she was working for some U.S. domestic concerns to do this because a lot of the folks were based in Houston. The 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 defense attorneys brought a motion to dismiss based on the Hoskins decision, which basically said that you can't charge a non-U.S. citizen working for a non-U.S. company who's never set foot in the United States with conspiring to violate the FCPA because they're outside the scope. The judge dismissed the FCPA and the money laundering charges on a really extension of Hoskins that I don't think makes a lot of sense. But I think I understood. I had to read this decision a lot, and that's why it's 3 paragraphs here to try to understand it. Long story short is DOJ brought a conspiracy charge against the Swiss wealth manager, both based on being an agent of a domestic concern, meaning that she helped U.S. companies and U.S. people set up these vehicles to facilitate bribery, and on the territorial jurisdiction DD3 part of the FCPA. And I can see where that's a problem. There is no allegation that she stepped foot in the United States. And if you apply the logic of Hoskins, you can say, therefore, she doesn't fall within DD3, and you can't charge her with conspiring to violate DD3. I don't actually know why DOJ put DD3 in there, but they did. And the judge seems to have confused those two. Kind of melded the DD2 and the DD3 together in the Hoskins decision, and said basically you have to form the agency relationship in the United States for this to violate the FCPA. I don't think that's right. I think it was perhaps some confusion over the charging decisions. And DOJ immediately appealed. And I'm not a betting man, but if I were, I think that they have a very good chance of winning an appeal on the DD2 part of that, because it does seem, at least if the allegations are true, she was an agent of a domestic concern in that she acted on behalf of U.S. companies to set up these vehicles that allowed them to pay bribes. It'll be very interesting to see if that, what actually happens. Even if they succeed, they're going to have to be able to prove at trial that, she was acting in that capacity, that she knew what she was doing, that she was doing this intentionally for the purpose of assisting them in paying these bribes. So it's not a slam dunk, even if DOJ wins this appeal. But it seems to me that the judge probably got it wrong on some admittedly very arcane, as you said, geeky FCPA issues. So we'll have to see what happens in that one. A lot of people made, there's some commentary here about what an important decision this was, but I'm going to withhold judgment until we see what the Fifth Circuit does.
James, next up we had a summary of the SEC report and whistleblower tips and awards. And although not many of them are in the FCPA realm, we had a huge increase in fiscal year 2021. What did you see in this? And then I'm going to follow up on a question on the strategy of countering corruption around whistleblowers after you tell us about the SEC report.
Yeah, so every year in November, the SEC releases an annual report to Congress regarding the Dodd-Frank whistleblower program. We've consistently seen an upward trajectory, but 2021 was just kind of that on steroids. SEC reported that they received a 76% increase in tips from fiscal year 2020. It was the largest number of tips received in a single year. SEC also reported that they awarded over $500 million to over 100 individuals in fiscal year 2021. That was not only the largest dollar amount ever awarded in a year, it was not only the largest number of individuals awarded in a single year, but it was more than the amount of money awarded in 2021 was more than in all prior fiscal years combined. So it was just a very, very active whistleblower time for the SEC. As you mentioned, there was a 76%, as I said, there was a 76% increase in tips overall. And as you mentioned, Tom, that included FCPA tips increasing. They didn't increase by quite as much. There was a 24% increase in FCPA allegations from fiscal year 2020. But it just goes to show that whistleblowers are an issue for companies. The award program seems to be working in that it is generating more tips. And what that means is that companies are going to have to deal with more whistleblowers. Really important that companies take the time to look at what their reporting mechanisms are up to snuff, to make sure that you can, as much as possible, encourage internal whistleblowers. Make sure that you have your anti-retaliation policies in place, and make sure that your investigation procedures are in place, including thinking about how to provide updates to whistleblowers so that they feel satisfied by the internal process and don't go to the SEC or other enforcement agencies. Don't feel like they need to. Obviously can't prevent them, shouldn't prevent them from doing that, but make them feel like they're being heard and that things are being taken care of internally to at least reduce the impetus to go to the enforcement agencies.
We'll be right back with more from James Koukios after this message from our sponsor. James, what I wanted to maybe tie it into, we've seen other departments or agencies at least have whistleblower awards in 2021. The AML law of 2020 specifically had a whistleblower provision, but I wanted to ask you about one of the components on the strategy on countering corruption, specifically called out whistleblowers. And I guess I just wanted to ask, do you see this as the government seeing this as a very valuable initiative that is given the U.S. government tangible result that they're going to continue to advocate for whistleblower protection and whistleblower awards, now perhaps even on a broader basis?
That's exactly what it seems like. SEC has seen all these increases. They're giving out more awards, which suggests that they feel like the tips they're getting are valuable. And we do see the other agencies now thinking about having their own whistleblower rewards programs as well. So it does seem like this is a trend that's going to continue.
James, our next case or matter is a FCPA individual enforcement action. And I'm proud that we can actually talk about one that does not relate to PDVSA, number one. But number two, this one had some interesting issues around ephemeral messaging. So I was wondering if you could tell us about Frederick Cushmore, how he got into trouble, and how you use this as a teaching moment.
Sure. So he was the defendant, Frederick Cushmore Jr., was a former vice president and head of international sales at a Pennsylvania-based coal company. And he was allegedly and pled guilty to a scheme to bribe officials of an Egyptian state-owned enterprise for the purpose of obtaining approximately $143 million in coal contracts over a period of about 4 or 5 years. And the thing that as far as that goes, it's a fairly typical FCPA fact pattern. You've got a domestic concern paying bribes to state-owned officials of state-owned enterprise to get business. What I did really find interesting, Tom, and what you alluded to was there were some very specific and pointed references in the resolution about the use of ephemeral messaging. There was an allegation in the information to which he pled guilty. There were several that really emphasized that Cushmore and his conspirators were specifically using ephemeral messaging systems. In this case, it was WhatsApp, because they thought it would help them get away with it and not get caught. And so I quoted one of the allegations in there, which was that Cushmore allegedly instructed one of his co-conspirators to, quote, do more on this since it's encrypted, unquote. And that was a very clear message. Not only did it, show criminal intent, which is always good for DOJ, but I think that they really wanted to emphasize this because they really do see encrypted messages as a real compliance problem for companies and a way that, bad guys are trying to get away with this. When I started at DOJ, it was Hotmail and Gmail and Yahoo, right? Individuals moved from their work email accounts to their personal email accounts, not realizing that law enforcement could get those records through subpoenas. And I made a lot of great cases that way. And then people figured out, hey, we really, maybe shouldn't use Gmail and Hotmail and Yahoo anymore, and we should go to something else. And they started using text messaging. But you know what? You can also get that through subpoenas oftentimes, things like that. And so, it's always the cat and mouse game. But I think DOJ now sees, especially with the proliferation of these, WhatsApps and WeChats and things like that, that they really need to emphasize to companies that they need to get a hold of, get these things under control, because determined employees are using these things to try to commit crimes and get away with it. So this all started, there was the whole in the FCPA corporate enforcement policy where it started out by saying, you have to ban ephemeral messaging. And then there's a big uproar from the business community, like, well, we can't do that. Sometimes that's what our customers use. If you're in Brazil, everybody uses WhatsApp. They don't have great cellular service. They have better Wi-Fi, or they don't trust the government because they want to use an encrypted service. And WeChat, in China, everybody uses WeChat. And so they relaxed it, obviously, a little bit, but they're still trying to send the message to companies, you have to do something about this. We may give you a little more discretion on what to do, but you got to do something because people are getting, this is what your employees are doing. So I just found that to be a very interesting part of that resolution that I wanted to emphasize.
James, for our final matter from your November newsletter, we had a really interesting, once again, individual FCPA enforcement action, but this one involving adoption and visa issues. And what struck me, and I don't want to say why I like this case so much, because I don't want anyone to ever have to plead guilty, but I found it to be an incredibly powerful learning tool because it was really outside the kind of standard business type bribe. So what did you see in this case that interested you, and how do you use it as a teaching moment or lesson learned?
It's interesting, Tom. I mean, this was actually a recurring issue when I was at DOJ. The concerns about bribery in the international adoption sphere, for a lot of reasons. Oftentimes, and I cite the FCPA opinion procedure releases in our news release. A lot of times, officials from countries where children are being adopted from those countries to the United States, they want to come to the United States to make sure that the adoption agencies are treating them well and that the children from their country are being taken care of and treated correctly. And the question in those cases was always, well, can we pay for them to do that? As the adoption agency, can we pay to bring the foreign officials over here for this reason? And so there were a number of FCPA opinion procedure releases that we did on that issue. At the same time, there's an even more unseemly side of the international adoption, where, at least if this case is accurate, people are actually paying bribes to local officials to do things like terminate parental rights, to pay bribes to judges to terminate parental rights so that the children can be adopted from the country into the United States. Paying bribes to various other parts of the probation officers to find that, parents are unfit, things like that, to try to facilitate the adoption. It's very tragic. People are being robbed of their children because of this. And it turns out, like it or not, international adoption is a business. And so people are paying bribes to facilitate that business. And it's really sad and unseemly unfortunate part of it. And this is part of it's related to one of the only adoption related guilty pleas, which was from back in August 2019. This is another person in the same conspiracy. But I think, there's a couple things to be learned here. It's not just paying bribes to get a contract. DOJ and the courts have taken a broad view of business purpose, and courts have agreed with that. And, they've brought in enforcement actions like this one, saying, like, look, it's not just paying a government contracting officer to get a contract or paying somebody to get an oil field lease. If you bribe a judge to get a favorable decision that helps your business, that's an FCPA violation too. If you bribe a probation officer or a court registrar for some decision that helps your business, that can be an FCPA violation too. And so I think that's to help people realize it's broader than just paying money for a contract.
Well, James, unfortunately, we are near the end of our time for this episode. But as always, I learned a lot, and I have a new guidepost for how good I think podcasts are. It's number one, how much fun I have, or number two, how much I learned. And I had a ton of fun, and I learned a lot. So I look forward to visiting with you on the next series of MoFo International Anti-Corruption Development newsletters. Thanks again.
Well, it's always fun when we can start out by talking about a victory over Ohio State. It's been pretty few and far between over the last couple of years. Let's hope that this is just the first of many.
Amen.
Thanks, Tom.
This is Tom Fox again. Thank you for listening to this episode of the FCPA Compliance Report. I hope you will check out my 5-part podcast series on the trial of the century, the Enron trial, which recently premiered on the Compliance Podcast Network. In this podcast series, I visit with business journalist Lauren Steffi, who covered the trial for the Houston Chronicle as its business columnist. We take a look at what led to the trial, some of the key witnesses and moments from the trial, and what the trial inevitably meant going forward. It's a fascinating look at the Enron trial some 15 years after it occurred. I know you'll enjoy this special podcast series. The FCPA Compliance Report is a production of the Compliance Podcast Network.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.